All right, good afternoon, everyone. I'm Judge Corey Amanda Cotham. We're here for the afternoon session of First Appearance Court. I will start with our first appearance docket for this afternoon, and then we will go to the hearing docket. Just a reminder to everyone that everything we say is being recorded and can be used against you at a later date. And so I do encourage you to speak to your attorneys before speaking on the record this afternoon. Before we get started, are there any individuals that the jail needs called out of turn?
No, Judge.
All right. I do have Mr. Plant is here on 2 of the MO cases. If we have them present, I'll take them out of turn. The first on my list is Jermaine Lynch, who's on page 3.
Mr. Lynch, come on up, please. He's approaching Judge Maine.
Thank you. Thank you. Good afternoon, Mr. Lynch.
Hello.
Mr. Lynch, you are before the court this afternoon on 3 misdemeanor capiases. These are municipal ordinance violations for charges related to open container, urinating in public, and possession of drug paraphernalia. I find probable cause for these charges, and your attorney, Mr. Plant, is present with me in the courtroom. Mr. Plant, what are we doing with Mr. Lynch's case?
Judge, I read his probable cause affidavit.
Yes.
I don't know if the court would be so inclined to resolve his case.
I'm sorry?
It's due to the nature of charge, maybe it's better if we went to division.
Go to division?
We'll see
Okay.
tomorrow.
All right,
One of the
so,
charges, I mean.
Mr. Lynch, I'm gonna leave the bonds in place since these are capiases that the judge already set the bond on. I'm gonna leave that in place, and you're going to see your division judge on today's the 18th, so that'll be on
Actually,
Thursday. Okay? So you'll have a hearing with your division judge on Thursday, okay? All right, good luck. Okay, and the second case is Tyrone Garvey, who's also on page 3.
Mr. Garvey?
He's bonded out?
Bonded?
Okay.
Okay. All right.
Judge, I believe
Yeah.
there's a gentleman on the second look docket,
Yes,
Israel Jesus Salazar, that is also here on the municipal ordinance.
Okay, let me take a look.
Salazar. He came through Friday afternoon.
Yes, on page 2 of the misdemeanor docket.
We spoke with him.
He's got a $100 bond, is that right?
Yes, sir.
Approaching Judge.
Thank you. All right, good afternoon, Mr. Salazar.
Hi, how you doing?
I'm well. Mr. Salazar, you're here for a second look hearing this afternoon. I see your bond is currently set at $100. And your attorney, Mr. Plant, is with me here in the courtroom. And Mr. Plant, what do you want to tell me about his case?
Your Honor, he was in front of me. We've already tried to resolve him, so this is his second.
I'm sorry, say that one more
We're
time.
trying to resolve his case. It's a time served. I remember he
Oh, was this on Thursday
yes,
when I was
Thursday
gone?
afternoon, right? Yeah.
Okay, what's his offer?
Friday.
No.
No, it was yeah. Yeah, it came this weekend only. It came.
Okay, so you're trying to resolve it.
Yes.
What's the offer?
Time served, Your Honor.
All right. Mr. Salazar, if you want to resolve the case today, the city's offer is an adjudication, time served. Do you understand that?
No.
You don't understand that?
No.
So, Judge, it was Friday afternoon.
Okay, I do remember now. Okay, I do remember now. All right, so I remember the hearing now. So what I'm going to do is leave the bond in place so that he can go to division and see what's going on with it, okay? All right.
No, he only speaks Spanish. You don't understand at all.
Gentlemen, please.
¿Quieres hacerlo en español?
Let's figure it out.
We tried.
We tried it
Yeah,
before.
we tried.
Okay.
It wasn't-
All right. Good luck, Mr. Salazar. Okay, I'm going to leave the bond in place.
Thank you, Judge.
Thank you.
Siéntese.
All right. Thank you.
Salazar.
Okay.
Salazar.
Venga, señor, por aquí.
Okay.
Síguele.
All right, so let's go to our regular list here. I have Jerry Washington was reset from this morning's docket. Do they have him present at Maine now?
Yes, Judge.
Okay.
I believe Mr. Jerry Washington, correct, Judge?
Yes, that's correct.
Mr. Washington, come on up, sir.
All right, and let me just make sure for my finding sheet, we're only here on count one, right?
We're only here on count one, Your Honor, but you're gonna have to set,
Yeah, okay.
since none of them should be no bond, you're ultimately, you know.
Okay, all right, we'll go through it together. All right, good afternoon, Mr. Washington.
How you doing, Your Honor?
I am well. So, Mr. Washington, we're here to get this case ironed out today. So you have an ad charge, all right, and a capias was generated as a result of that. And this is a charge for battery on a law enforcement officer. Is that right, Mr. Linder?
That was the ad charge.
That's the ad charge. Okay, so tell me what we need to address today for Mr. Washington.
So, Judge, just to remind the court, back in January when this case came through, you set the resisting with violence at a $500 bond.
Okay,
And there was no charge for the resisting without violence. And so I would ask the court to reinstate count two to a $500 bond, and considering it's actually the same charge, count one, also $500.
I'm fine with that, Judge.
okay. So on my finding sheet, we've only got one count to address because you just said two.
Yes.
So I want to make sure we're,
Yeah, basically what I would recommend is, on the one count on your finding sheet,
yes.
one, the Bat Leo, set that at 500. You can write in count two, resisting officer with violence, and place that back at 500. His bondsman that posted his bond originally, I'm sure will have no issue, filing an affidavit to stay on the bond.
All right, so I've got the felony capias, which is the ad charge. That's going to be set at 500, and then I'm going to add in resisting with violence, and that will be set back at 500, correct?
Yes, and then you just have to write in resist, obstruct without violence, and set that back at an ROR.
Mr. Miller, you're good with that?
Yes, Judge.
These are all the same case number, correct?
Yes, Judge.
Does it matter what numbers are associated with the charges on here? Because I have the court order listed, which is why I'm asking.
Let me check BSO pics to make
Judge,
sure.
I'm looking at BSO pics. Count
Yes.
one was the battery on a law enforcement officer. Count
Yes.
two was resisting with, and count three was resisting without.
All right, and then do we need to separately address the court order that was entered by Judge Evans?
I don't know if does the jail need an order vacating that previous order? No?
Okay, because on my finding sheet, it has listed the court order with no bond associated with it. That's why I'm asking.
Oh, if it's on there, then we're just making an RO, yeah. No,
No, it was generated because of the order that Judge Evans
was
entered
created
when he was
separately.
remanded yesterday.
they put the not in custody capias and from the court order.
Yep, so, okay, so that we're all on the same page, the felony capias that's on the finding sheet, which is the ad charge for the battery, is listed at 500. The court orders that are showing at no bond on my finding sheet, I'm changing from no bond to ROR, so that's not an issue now. And I'm adding in the resisting with violence to 500, resisting without is ROR. Okay? We're all good. Okay, all right. I'm glad we were able to get that sorted out. All right. Okay, next is going to be Kathy Franklin.
Ms. Franklin, is it North Broward, Judge?
Good morning.
Do you need the paperwork? Okay, good morning, Ms. Franklin.
Judge,
Good morning.
Mr. Linder has extended an offer.
Okay, one moment.
Before we get too far to Mr.
One moment,
Feltes,
one moment. right, can I have the paperwork for Washington?
I'm being advised, Your Honor, if you could just cross out the court order, no bond.
Yeah, that's what I was thinking.
That way we don't have an ROR and a $500 bond in the same count.
Yeah, that's what I thought too. Okay, that makes much more sense. Okay, thank you. Okay, all right, so now let's go to Ms. Franklin's case. And Mr. Miller, you said that she wants to resolve the case?
Yes, Your Honor. Mr. Linder offered a withhold and court costs. I have advised Ms. Franklin that this is at least strike two, and what the future will hold if she gets picked up on another petty theft.
Okay, all right, so Ms. Franklin, you understand all of that?
Yes, ma'am.
All right, and you want to resolve the case today and accept that offer?
Yes, ma'am.
Okay, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you, and now you can put your hand down. And Ms. Franklin, you understand everything that we've discussed here today, correct?
Yes, ma'am.
All right, is anyone forcing you to resolve this case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
And Ms. Franklin, what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea and find that it's freely and voluntarily given. Your sentence will be a withhold of adjudication plus court costs. Good luck to you.
As soon as they release me, I'm able to go.
Yes, you'll be released. If there's nothing else holding you, then you'll be released.
Thank you.
All right, you're welcome.
Come on.
Next will be Glenda Garcia.
Also at North Broward.
Okay. All right. Good afternoon, Ms. Garcia.
Yes.
Ms. Garcia, you're before the court this afternoon on 8 charges. Count 1, possession of fentanyl. Count 2, possession of heroin. Count 3, possession of alprazolam. Count 4, DUI, alcohol or drugs, second offense. Count 5, refusing to submit to a DUI test. Count 6, reckless driving, first offense. Count 7, parking in a disabled parking space improperly. Count 8, not carrying or exhibiting a driver's license. The last 2 counts, 7 and 8, are not for magistrate. I find probable cause, and I will hear from the parties at this time. Okay.
That's the court to keep the bonds in place. This is, from what I can tell, this is actually not Ms. Garcia's second DUI. This is her third DUI. She put out 2 separate DUIs in 2010, both with injury or property damage.
All right. Mr. Miller.
Okay. So I spoke with Ms. Garcia a little earlier. She is a lifetime resident of South Florida. She's been living in her current address for about 6 months. She is disabled in the process of obtaining SSI, relying on her mother for support and for assistance. She advises that she can do pretrial if the court would agree to put her on pretrial release. She does have 4 animals at home, a dog and 3 cats that need her to get home to feed them.
Just noting the driving pattern here and what I'm observing this afternoon, I've got some concerns.
All right. Based on Ms. Garcia's prior history with DUIs and the allegations in this case, I'm obviously very concerned. The probable cause affidavit is rather lengthy and gives me some very serious concerns as to both Ms. Garcia's safety as well as the safety of the community. So at this time, I'm not going to place her on pretrial. I'm going to leave the standard bonds in place on counts 1 through 6.
Thank you, Judge.
Thank you. James Devillon. Thank you. Tyrone Hughley.
medical reset.
All right.
Mr. Bernard Osius.
I'm sorry? Which one? He bonded, yeah, he bonded. Good afternoon, Mr. Osius. Mr. Osius, you're before the court this afternoon on an ad charge. This is a charge for battery by a person detained in prison or a jail facility. I find probable cause, and I'll hear from the
Judge, at this
parties.
time, nothing to have from the defense. The only thing, because he's being held no bond, represented by the PD's office, he just wanted to know, when's the date of this allegation?
December 7th, 2019. Okay. All right, I'll leave the bond in place. Thank you. Brian Johnson.
Mr. Johnson is here. Come on up, Mr. Johnson. Please approach the judge. Come on
Thank
up.
you. Good afternoon, Mr. Johnson.
Yes, ma'am.
Mr. Johnson, you're before the court this afternoon on 6 charges. Count 1 is for resisting an officer obstructing without violence. Count 2, possession of MDMA. Count 3 is a bike regulation violation for not having a light at night. That is not for magistrate. Counts 4, 5, and 6 are felony probation violations which have no bond holds. I find probable cause. Mr. Johnson, I do see you have a hearing with your division judge on the VOPs tomorrow morning. In light of that, do the parties wish to be heard on count 2?
No, Judge.
All right, that'll remain in place. Thank you. Jeremy Souza.
Mr. Sosa? Please approach, Judge. Come on up,
Thank
sir.
Good afternoon, Mr. Souza. You're before the court this afternoon on 2 charges. Count 1, possession of cocaine. Count 2, driving while license suspended, third or subsequent offense. I find probable cause, and I'll hear from the parties. Okay. Mr. Romero, go ahead.
Judge, Mr. Sosa is not going to be able to afford to post a monetary bond. Unfortunately, at this time, he's homeless. He works when he can in construction. He's been here his whole entire life. So he's asking to be released on pretrial release.
He's just on pretrial for a pending battery, and Judge Pohl signed a no bond revocation on January 29th. The warrant alleges that he is required to report 2 days per week via telephone. As of December 27, 2019, he has not reported to the pretrial services office via telephone. Attempts to contact the defendant have been unsuccessful, and his current whereabouts and activities are unknown.
So has that just not hit the system yet, since he doesn't have that on his?
No, it should be in the system. I mean, it was issued January 29th.
Nancy, are you showing it for pretrial?
It was a KPS. That's. See, there might be some confusion in it, because what I'm seeing in Odyssey, he filed a request for him to have a capias withdrawn, which Judge Pohl granted, and his explanation was, I don't drive and I underestimated the time for public transit. But that would have nothing to do with the warrant, because the warrant was alleging he just didn't call in. But there might have been some confusion with the recall capias being granted, that they recalled the violation of pretrial.
So the warrant has not been lifted by Judge Paul, is that what you're telling me?
I can't be certain, but it seems to be two different issues, because Judge Paul vacated the capias, which is different than,
Was the capias for a failure to appear? Because that's a completely different issue.
that's what I'm having a hard time telling, Your Honor. That's why it's so confusing.
Okay. That's all right. It's
And
not
I
before me
believe
today.
he has a court date coming up February 20th.
And already,
Because
All right.
the request that was made was recall the warrant for arrest and reset calendar call, which would seem to indicate it's for a failure to appear. Because why would you need a calendar call reset if it was just an issue of not calling pretrial?
Okay. Well, in any case, what I'm saying is that he was recently on pretrial and failed to abide by what he was supposed to. So I'm not going to put him back on pretrial. At this time, I'm going to leave the standard bonds in place. Courtney Moore.
Mr. Moore, come on up, please.
Judge, we have an argument as to count 2.
Okay. Good afternoon, Mr. Moore.
Governor,
Mr. Moore, you're before the court this afternoon on 2 charges. Count 1, operating without a valid driver's license. Count 2 is for grand theft auto. Mr. Miller, I will hear your argument at this time.
Thank you, Judge. So if you look at the second page of the probable cause affidavit, you'll see that the victim in this case is EAN Holdings, that's Enterprise Rental Car. And so that gives me cause to wonder what investigations law enforcement did regarding this case. There's nothing in this PC that says that Mr. Moore admitted knowing that this car was stolen. We don't know when the car was reported stolen. We don't know who originally rented the car. We don't know how he ended up in possession of it. And there's no indication that he knew that the car was stolen. And so I would argue that just simply being in possession of a stolen vehicle with nothing more does not give rise to probable cause to believe that Mr. Moore knew that the car was stolen or should have known. And so I'd argue there's no probable cause for grand theft auto in this case, Judge.
Okay. Mr. Linder.
Your Honor, I do believe that being in possession and control and driving and operating a stolen vehicle does give rise to probable cause. Now, if we were at a trial position where I had to prove beyond a reasonable doubt, then I would agree. I would need more evidence than him just being in possession of the vehicle. But for arrest purposes, for probable cause, I do think that would suffice.
Judge, an element of the theft crime, of any theft crime, is that they knew or should have known. And in this case, that element is completely missing from this probable cause affidavit.
And Your Honor, if someone is operating a motor vehicle, there's no one else in the vehicle, and there's drugs found in the vehicle, the case law is very clear that if you're in sole and possession and dominion of the vehicle, then it can be attributed to you. Just like in this situation, if he's the one operating the vehicle, again, for probable cause, the alternative is then law enforcement could essentially never be able to really make an arrest for grand theft auto unless the defendant admitted that he knew it was a stolen vehicle.
And Judge, I'm not trying to be clever here, and I'm certainly not
understand.
trying to be overly argumentative, but there was another person in the car at the time.
I understand. All right, what I'm saying here is that Mr. Moore was the driver. The car was confirmed stolen. While I absolutely understand, Mr. Miller, your argument with regard to some of the deficiencies that are here, I think that we have enough to reach a threshold of probable cause. Now, whether other information will come out later for filing purposes, that's going to be a whole separate issue. I understand what you both have said. Likely there would need to be more information with regard to actually pursuing the charges. But for today's purposes, for first appearances, I'm going to make a finding of probable cause. And at this time, I will hear the parties' recommendations as to bond.
Judge, I wonder, just based on the weakness of this case, if the court would just ROR him on count 2.
Well, let me hear the rest of the information. I'll take it into consideration.
Judge, in speaking with Mr. Moore, considering what my colleague has argued regarding mitigation of the strength or weakness of the case, would the court consider releasing him under a pretrial release?
Just so the
Supervision.
court's aware, in 2017, Mr. Moore had a grand theft auto conviction in Miami-Dade. On April 17, 2018, he was sentenced to 2 years in state prison and released September 22nd, 2019.
All right, at this time, I'm going to grant an ROR on count 2 and place Mr. Moore on standard pretrial supervision. Mr. Moore, Mr. Romero is going to give you some information about pretrial. Though you're going to be released today, you must report to pretrial supervision within 24 hours. If you fail to report to them, as I have instructed you, a warrant will be issued for your arrest. Do you understand?
Yes, ma'am.
All right, thank you. Kevon Wigley.
Mr. Wigley, come on up, please. He's approaching Judge here at Maine. Oh, Judge, Mr. Wigley declined the service as a public defender. He said he's gonna hire his own attorney, but he wanted to see if the court can see if his bond's been posted.
Okay, can we see if Mr. Wigley's bond was posted? Not showing? Okay. All right, Mr. Wigley, good afternoon. For the record, confinement is telling me that the system is not showing your bond as posted right now. Since I have you here, for the record, you are here on a charge for distributing or delivering cannabis. I find probable cause. I see the bond is set at $1,000. Mr. Linder, is there anything further?
No, Judge.
Okay, all right. So, Mr. Wigley, I'm gonna leave the $1,000 bond in place at this time, all right?
Okay.
Thank you. Good luck, sir. Steve Miklos.
Judge, he's at North Broward, and this is either a medical reset or he refused, but he won't be in court today.
Okay. All right, well, we'll reset him for tomorrow then. All right. Okay, so now we'll go over to our hearing docket. I'll start with the misdemeanor docket. The first on my list is Lamont Green.
He's approaching Judge is here at Maine. Come on up, Mr. Gray.
How you doing?
I'm well, Mr. Green. Good afternoon.
Good afternoon.
You are here on a second look hearing this afternoon. I see Mr. Green's bond is currently set at $100. I will hear from the parties at this time.
Judge, Mr. Green is asking to see if the state has a plea offer he wishes to resolve this matter today.
I believe I made it on Friday. He turned it down. It was 10 days. Just so the court's aware, Mr. Green has been through this division many times.
Oh, Scott Allen, he refused.
Judge, at this time, considering his credit for time served that he has in already, Mr. Green wishes to accept the state's offer.
All right. It's an adjudication 10 days, Mr. Linder?
Yes, Judge.
All right, Mr. Green, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you, and now you can put your hand down. Mr. Green, do you understand everything that's been discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, but myself.
Are you under the influence of drugs or alcohol?
No,
Do you need any more time to speak with your attorney?
no.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes. I'm from New Jersey, so you're right now, yeah.
Okay. All right, and Mr. Green, what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea and find that it's freely and voluntarily given. Your sentence will be an adjudication of guilt, 10 days in the county jail with credit for time served. All right, good luck, sir. All right, next will be Scott Allen. Is that the one you said refused?
Judge, that's correct. Considering Mr. Allen's recent history in MI division, I was wondering if the court would consider transferring this case.
Yeah, I'm fine with that. The only thing I find I'm curious about is I checked the pending battery case that's in front of Judge Carpenter Toy right now.
Yes.
With there's been a competency evaluation already done.
Was this the, I'm sorry, go ahead.
That's all right.
Is this the case that Judge Lerner Wren recused herself on one of his cases?
I don't know if it's that.
I remember
we'll
we had a
check.
conversation about one of the,
Yes,
is it his?
the open battery. She in November of 2019, she recused herself. So
Because I remember asking that question, Mr. Miller, about transferring him, and that's the issue, so. Yeah, if you guys want me to sign the order, I have no issue with doing it, I just don't know if she'll take it.
I just think if we could get him in front of Judge Carpenter Toy as quickly as possible, because even if you send him to Judge Lerner in that case, the battery case is still out there.
Right.
You know, better to deal with both at the same time and streamline.
I agree, they'll probably have the same issues. All right.
Do you have the battery case, the case number, Dale?
Oh, that I do have. One moment. It is case.
No, I have it. I just didn't know if you had it.
Yes, I'm just looking to see if we have any record of it in my office computer.
Yeah, you guys are definitely appointed on it. You guys are appointed, looks like January 15th. Can't be certain.
Is it him? I know that Judge Carpenter Toy would remember. Yeah.
I can't. I have no insight to offer, Judge.
Okay. All right, so what I will do for right now is, I'm gonna leave the $25 bond in place. Since he has the other case with Judge Carpenter Toy, hopefully she'll be able to address both of the issues at the same time if there's a competency issue. I do have a feeling, Mr. Linder, that you're right, it might be the same individual that we dealt with last week, or last month, excuse me. All right. Okay. All right, so let's go over to the felony docket now. The first on my list is Gary Thornton.
In jail.
He's here approaching. Mr. Thornton, come on up.
Judge, Mr. Thornton's been in custody for a total of 6 days. His bonds total $22.50.
Okay. Thank you. All right, good afternoon, Mr. Thornton. Mr. Thornton, you're here on a second look hearing this afternoon. Your total bond is currently set at $2,250. And there was an order that you're not to be driving, and I'll hear from the parties.
And Judge, Mr. Thornton, as you can see, no one can afford to post his bond. He lives in Pompano Beach with his sister. And Mr. Thornton works when he can. He's a handyman. And whenever he has no work as far as projects, he works in the labor pool. But no one's going to be able to afford to post his bond, so that's why he's wanting to be released under supervision, Judge.
Your Honor, I'm going to be asking the court to keep the bonds in place. One, just based on the allegations in this case, I know there's 2 reports. Also, just looking at his criminal history on just driving offenses, in 2008, he got sentenced to 10 years state prison as a habitual offender on a DWS habitual offender. In 06, almost 18 months on a DWS habitual offender. 06, again, almost 18 months on a DWS habitual offender. 04, 21 months on a DWS habitual offender. 04, another DWS habitual offender, 21 months state prison. And these are just the driving offenses. He's gone to state prison on felony battery due to priors. He was just released in March of 2019. Possession of cocaine, battery on a law enforcement officer, resisting with violence, depriving an officer of a weapon or communications device, felony battery due to priors, possession of cocaine, possession of cocaine, possession of cocaine, battery. Nothing further.
Mr. Romero, where does Mr. Thornton live?
In Pompano Beach with his sister, Judge.
All right, just so he knows, I'm not showing a Pompano address for him, so if that's not correct, he needs to make sure to let the clerk's office know that so that they can have the correct address to send his court notices.
Yes, Judge.
Mr. Thornton, so though I am concerned with your prior driving record, since I'm not dealing with any violent offenses today, I'm willing to place you on pretrial supervision with a few conditions. Number 1, you're going to be subjected to random drug and alcohol testing. That means no alcohol, no intoxicants. Do you understand that?
Yes, ma'am.
And number 2, you are not to be driving. I already imposed a no driving order, but I'm saying it one more time. Do you understand that?
Yes, ma'am.
All right. Though you are going to be released today, as I will be RORing you, Mr. Romero is giving you some information there regarding pretrial supervision. You must report to pretrial within 24 hours. If you fail to report to them as I've instructed you, a warrant will be issued for your arrest. Do you understand that, sir?
Yes, ma'am.
All right. Additionally, as you heard me say to Mr. Romero already, it's going to be your responsibility to contact the clerk's office to make sure they have your correct address so that they know where your court notices are to go and so that you are aware of any future court dates you have to be present for. Do you understand?
Yes, ma'am. I sure will.
All right. Thank you very much. Good luck. Next will be Patrick D'Amico.
North Broward, Judge.
Thank you.
Judge, Mr. D'Amico's been in custody for 6 days. His total bonds are $1,500. I think it's 2 counts.
Yes.
We are seeking pretrial release for him. No one has been able to post his bond as of yet. He is a 20-year resident of South Florida. He works as a diesel mechanic. He's advising me that he served 10 years in the United States Marine Corps and was honorably discharged. And I've discussed with him the possibility of transferring this case to Veterans Court.
Go ahead.
Your Honor, he just got out of jail January 17th. That was after he was sentenced to 270 days on a felony theft, grand theft, felony theft, another felony theft, another grand theft. On one of those, at least one of those cases, he was picked up on a violation of pretrial. That was for theft and fraudulently obtaining merchandise or money. He was placed on a GPS monitor by Judge Garcia Wood. he removed the GPS monitor. And then he was only arrested on that revocation because he was stealing again. In addition to his priors, 2016 grand theft, 30-month state prison as a habitual offender. 2014 grand theft, 30-month state prison as a habitual offender. 2014 felony theft, 30 months state prison. Theft 2013. Grand theft 2012 VOP, 364 days county jail. Grand theft 2012 VOP, 364 days. Theft 2011, felony theft 2011 with a VOP. Grand theft 2010 with a VOP. Theft 09, felony theft 09, a year and a day state prison. Felony theft 09, a year and a day state prison. Felony theft 08, grand theft 07, grand theft 07, grand theft auto 05, VOP, a year and a day state prison.
No grand theft auto.
Grand theft auto and grand theft 04, theft 04, 2 counts of dealing in stolen property 02.
All right, at this time, I'm gonna leave the bonds in place on Mr. D'Amico's case.
Thank you, Judge.
Thank you. Good luck, Mr. D'Amico.
Thank you.
Maurice Major.
What's that?
Come on up. He's approaching, Judge.
Thank you. Good afternoon, Mr. Major.
I really want to Canada off.
Mr. Major, you're here for a second look hearing this afternoon. Your bond is currently set at $750. I will hear from the parties at this time.
One moment, Judge. Judge, Mr. Maurice is homeless, but Judge, he's on this nonviolent offense. He's asking for the court to consider straight ROR, not pretrial.
The state would be opposed to an outright ROR.
What else, Mr. Linder?
Showing battery 2019, resisting without violence 2019, theft 2018, grand theft 2018, VOP 364 days, theft 2018, possession of cocaine 2017, possession of PVP 2015 with the VOP, possession of PVP 2015, VOP.
Failures to appear?
I'd have to check. Oh, I'm showing right now, in 2018, he was placed on pretrial with a GPS monitor for grand theft and resisting with violence. Within 5 days of his release, pretrial had to seek a revocation warrant. It says that he was released from custody he was placed on pretrial October 5th. On October 6th, at approximately 5 o'clock, he failed to report to his approved residence after his release from custody. He was instructed to go directly to his residence. He was tracked via GPS monitor to numerous residential homes. He also failed to keep his ankle monitor charged, rendering the unit inoperable. As of the writing of the warrant, pretrial had no idea about his whereabouts or activities.
All right, I'm gonna leave the bond in place at this time on Mr. Major's case.
Yes, Judge.
Thank you. Good luck, Mr. Major. Next will be Travis Coney.
He's approaching, Judge. Mr. Coney, come on up, please.
Thank you. Good afternoon, Mr. Coney.
Good afternoon.
You were here for a second look this afternoon. Your bond is currently set at $2,000 total. I will hear from the parties.
Judge, Mr. Coney, he can't post bond. He lives in Pompano Beach with his grandmother. He's not working. He's looking for employment. He's asking to be released under a pretrial release, Judge.
Mr. Coney was arrested last April on a capias for failing to appear in court. In 2017, he was arrested for a violation of his pretrial on an aggravated assault case that he was ultimately convicted of. He was placed on pretrial May 12, 2017. Within 2 weeks of being released, he removed the GPS monitor. And, pretrial, let me just see. Pretrial did not know about his whereabouts or activities, and I'm also showing he was arrested in May of 2016 for 2 separate capiases for failing to appear. July of 2015 on a capias, March of 2015 on a capias.
Judge, obviously from what the state is reciting, Mr. Coney has a bad track record. However, I'm asking you to take a chance on pretrial based on what's currently before you. Now, I haven't had an opportunity to review the PC affidavit. One glaring thing is I believe the initial contact was pursuant for a bicycle light infraction. So based on the bicycle light, my understanding for purposes of giving the ticket, that's the only thing that the law enforcement can detain him for purposes of that. I don't know what led to the discovery of the drugs. Maybe Mr. Coney was cooperative and volunteered that information to the officers. If that's the case, based on his cooperation, I'm going to be asking the court to take a chance on Mr. Coney and release him on pretrial release with condition as far as him being subject to random drug testing. But if that's not the case, then if it wasn't pursuant to Mr. Coney's cooperation, then certainly there may be a potential motion to suppress in the future. So based on what's currently before the court, that is why I'm asking for Mr. Coney to be released in the pretrial release.
Where does he live right now, Mr. Romero?
Let the court know where you live.
I live at 333 Northwest 5th Street, Pompano Beach, Florida, apartment 2.
And who else lives there, Mr. Coney?
Me, my grandfather, my cousin, and her 2 daughters.
How long have you lived there?
I have lived there ever since I got out my bid with the aggravated assault. That was 2 years ago, basically 2 years. I've been there staying there my whole life until my grandmother passed. And I'm staying with my granddaddy now. He like going through with dialysis. He be having to go to doctor every now and then. So I have to be there sometimes to watch my little nieces.
All right. Well, here is what I will do. Anytime that I'm told someone has been on pretrial rather recently and has cut a GPS monitor off of themselves, I'm not normally inclined to put them back on pretrial. That's obviously extremely serious. I do understand that these are drug possession cases, so they're not anything to do with violent crimes or anything like that. So I'm willing to take a chance on Mr. Coney, but it's going to be subject to a couple of things. If I put him on pretrial supervision, it's going to be pending verification of the address. So pretrial is going to call or go there to make sure that's where you're going to be staying with those
Yes,
family
ma'am.
members. And
Yes,
you would
ma'am.
be subjected to random drug and alcohol testing.
Yes, ma'am.
That means that if you violate pretrial or if you fail to come to your court dates, the consequences may lead to a warrant being issued for your arrest. And if grandpa's going through his own medical conditions, he doesn't need to be concerned with you being out missing and not going to court, right?
Yes, ma'am.
All right, so I'll sign the order for you to be released to pretrial. As I said, that's going to be subject to pretrial verifying the address. If they cannot verify that that's where you're going to be residing, then the bond will remain in place. If they are able to verify it, then you'll be released to pretrial. And as I said, the random drug and alcohol testing is going to be in effect, all right?
Yes.
All right, Mr. Coney. Good luck. Next is going to be Sibthorpe Latour Clark.
I'm sorry, Judge, who did you call?
It's Sibthorpe Latour Clark.
Oh, come on up, sir. He's approached, Judge.
Thank you. Good afternoon, Mr. Clark.
Good afternoon, Judge.
Mr. Clark, you're here on a second look hearing this afternoon. I'll hear from the parties.
Judge, as you could see, he has a $4,625 bond. There's no way he can afford to post that bond, nor does he know anyone that can post that bond. He's been living in our community since he was 11 years old. He's 27. He does have a mailing address where he can make sure to receive future court notices, so make sure he doesn't miss court. Right now, he's not. He's looking for employment. He does labor pool in the meantime, but no one can afford to post his bond, so that's why he's asking to be released under supervision.
State would oppose. This is now his third arrest since he got arrested in June for possession of cocaine that is still pending. He was first arrested on a petty theft resisting without violence. He pled that out. Then he was arrested January 12th of this year on a petty theft and a capias on a trespass that he failed to appear in court on. And now he's back again a month later for a new theft case, this involving felonies. I mean, how many times does he have to get arrested with new offenses with a pending felony before he's not given the benefit of the doubt?
Is he out on bond in the possession of cocaine case
He
right
is $1,000 bond.
now? All right, at this time, I'm going to leave the bonds in place on Mr. Clark's case.
Let me call this guy first.
All right, that brings us to the end of our docket for today for first appearances, so I'll see everyone tomorrow morning. Thank you.